SJC-11484, Commonwealth v. Derek D. Waller.
Mr. Curran, good morning.
Good morning. May it please the court, Dana Curhan for Derek Waller. I want to talk about two issues. One issue is preserved. One issue is not only not preserved, but actually specifically waived. That will be the...
Well, I'm not sure the lay opinion is preserved, though.
Okay, well, the lay opinion, there was an objection. When you look at volume 4, page 30, there's a general objection that's overruled. There is then another question where there's a relevancy objection. That may have been a little bit off point. I think the proper argument is that the prejudicial value outweighs the relevance. The question was repeated on page 36. That objection was sustained, and on pages 39 and 40, again, there was a general objection. The question was answered, and the witness said something to the effect of, I got out of town because I don't want to be around shootings and murders.
Right, but your problem is not weighing probative value and undue prejudice. Your problem is that in explaining why Varner left, implicit in it is a lay opinion that the defendant was the shooter.
That's right.
Okay, that objection was never made.
Well, there were general objections made. There were 3 general objections made.
Yeah, but there's be a specific objection so that the judge has an opportunity to contemplate whether or not this may include lay opinion.
Well, I mean, I think it's fairly obvious that it did include a lay opinion. He didn't ask for clarification. He didn't say, what's your objection? There was an objection, and that was repeated 3 times. And he sustained it once, and he overruled it twice. So I think that's enough to preserve that objection. And I think even if we look at it under a substantial likelihood of a miscarriage of justice, the defendant, the witness in this case, who had particular knowledge of, or a particular knowledge of some of the facts, expressed an opinion that, in effect, the defendant committed murder.
Yeah, I know, but it's a relevance objection. It's clearly relevant as to why Varner left. It's not just Waller who left town, Varner left town. It's obviously relevant while Varner left, especially since there's a suggestion that he may have been the shooter. So there's a relevance objection, and the evidence is clearly relevant.
Well, I think if he said, I don't want to be involved in whatever was going on, without expressing an opinion that I don't want to be involved in, the first time he said shootings, the second time he said shootings and murder, I think that is a conclusion.
I'm not disagreeing with you about whether it's lay opinion or not. That's a whole other issue. I'm not disagreeing with you whether it's lay opinion implicit in the answer. What I'm saying is that it's not preserved, and it's going to be a substantial likelihood of a miscarriage of justice analysis. I don't see how a relevancy objection to something that's clearly relevant is preserved.
Well, I mean, again, I'd say that there were 4 objections. One of them was relevance, and
there wasn't grounds for the other ones.
The other ones, I think, again, he didn't articulate it.
Right. That's
so
what you do to preserve.
Maybe well, if you object to something and the grounds for the objection are reasonably clear to the judge, then I think that is preserved.
Once the answer was given, perhaps, but there's no motion to strike. There's nothing obvious about what the answer was going to be.
If that's the case, it will. We do contend that it was sufficiently egregious to be a substantial likelihood of a miscarriage of justice.
Right.
But
the question that was asked, which was objected to, was what?
The question was
Why did you leave town? Was that what that? or something?
Something to that effect.
And that, the question's, are the questions appropriate, isn't it?
I don't think the question is necessarily appropriate. I think,
Why would it not be appropriate when the Commonwealth is going to argue that Mr. Waller's leaving town after the shooting is consciousness of guilt, but it wasn't only him who left town, it was also Mr. Varner, who also had been in a fight with this particular victim at the bar before he was killed. So why is it not relevant to the jury to understand why Varner left town?
I suppose you could ask something to that effect, but the thing is, the answer that kept coming out was something that was an opinion, and it actually came out twice. The judge sustained one of the objections and overruled two of them, plus the relevance objection. I think it's the answer that's really problematic, and particularly the answer on page 40, where he said, I don't want to be around murders.
How much,
But that's why he left town. And that was his state of mind, was I don't want to be around shootings and killings, or shootings and murders.
Well, I think the reference to murders and the reference to shootings, I think when you look at it in the context of his testimony, where he described all of the events that night, he wasn't there for the murder, but he described all of the events, he is effectively drawing a conclusion that Waller committed a murder and not him.
but Mr. Curhan, as far as the prejudice or the substantial likelihood of miscarriage of justice, depending on whether it's preserved or not, it's the same credibility determination as the ultimate credibility determination of Mr. Varner as to all of his testimony about what the defendant allegedly said. There's no additional credibility required of the jury because of the answers to these questions. It's any different than determining whether or not they credit Mr. Varner.
I don't think it's a question of crediting Mr. Varner. I think it's a question of eliciting an opinion as to the defendant's guilt. I draw a distinction between this is what happened. He got in the car and he drove away, and we tried to call him. When we came back, he emptied out a revolver, and there were two. That's all fine. But when you talk about the conclusion that he draws.
But he's not a precipient witness. Varner's not a precipient witness to the shooting.
That's right.
So anything that he has to say about the shooting is the same credibility determination involved in Mr. Varner generally.
I disagree. I say that because he wasn't involved in the shooting and he didn't directly witness the shooting, allowing him to express an opinion that I got out of there because I don't want to be around murders, I think is problematic.
Okay, so accepting that it's problematic, and whether it's a substantial likelihood or whether it's prejudicial error, can you put the error in context of the case for me so that I see why a reversal, as you advocate, would be appropriate?
Well, because again, there was at least some room for, there was a possibility of self-defense, there was a possibility of excessive force in self-defense, which I will get to in a minute, but he essentially draws the conclusion and expresses to the jury that his belief that Waller committed the murder. Not just that he did the shooting.
But in the context of the other evidence, does it matter really?
I think it probably does. And, trial counsel did not do a particularly good job. I think this was his first murder case, and there's not a lot that's preserved in this trial. I mean, he actually recognized this as an issue and actually objected. He could have articulated it better, but I think he was right.
Well, you'd also make the point that it gets mentioned in the closing.
It does. I think that really compounds it, and it becomes problematic. and I can leave it at that and turn to the next issue. We challenge the lack of an instruction on self-defense. Now, I'm not going to criticize Justice Gaziano in any way. He handled it
Very smart.
correctly. He said, hey, look, this is a self-defense case, or there's evidence raising self-defense, and I will instruct on self-defense, and I will instruct on excessive force in self-defense as constituting manslaughter. And defense counsel said, well, no, I don't want to put him at the scene. I don't want to concede that he's the shooter, so for tactical reasons, I'm actually asking that you not instruct on self-defense. And Justice Gaziano actually gave a colloquy to the defendant. Here is the problem. There are a couple of problems. The first is that there is about a 99.8% chance that the jury is going to find that he's the shooter. And once they get to that point, now there's no defense. And there's no defense in circumstances where there is a reasonable basis for arguing self-defense or excessive force in self-defense. And I think, and so when Justice Gaziano said, look, I'm instructing you as a matter of law that self-defense or excessive force in self-defense is not an issue, that just took it away from the jury. Now, the second problem is that...
Before you get to the second problem, though, the Commonwealth's position is because your client provoked the assault that there actually wasn't, in the light most favorable to the defendant, a right to a self-defense instruction.
Well, I disagree, because at the club...
You disagree that... you know that that's their argument, though.
Well, I know that that's one of their arguments. I mean, I disagree with that, because I think during the altercation at the club, the victim said to a friend, "Where's your thing?" And then on the way out, when they were yelling at each other, he pointed his finger at him as if he had a gun. And according to the defendant, when he told the story to everybody about what happened, he said he pulled up and the guy was walking toward me and reached for his thing, or essentially reached for a gun. I mean, that would be, I disagree that that is provoking him. Maybe he's going there looking for a fist fight. Maybe he's going there to yell at him some more, but I think the jury could, properly instructed jury could find that he went there, and before anything happened, the victim came out and reached for a gun, which caused him to pull a gun out and shoot him. Now, that could be self-defense. It could be excessive force in self-defense, constituting only manslaughter.
So what do we do with the fact that you, being a very capable attorney, if Justice Gaziano had done what you tell us now he should have done, and you didn't have the argument you have today, you'd instead be arguing that Justice Gaziano denied your client the opportunity to pursue his defense because he imposed a self-defense instruction over the objection of the defendant, and that deprived the defendant of his opportunity to present his true defense, which was that he wasn't there and didn't do it.
Maybe I would raise that same claim. I kind of doubt I would, but I think the answer to that claim is that Judge Gaziano instructed properly on the law, so I'm out of luck. And there's a line of cases where that, that argument has been made and rejected. It doesn't matter. When you're doing, when you're waiving a defense that is supported by the evidence, or you're doing an all-or-nothing defense and asking the judge to not instruct on some lesser included that's supported by the law, what you're trying to do is you're trying to get the jury to force the jury into the corner, like hold their nose and say, well, I don't think he's guilty of first degree, but he's guilty of something, but we don't have any instructions to tell us what he's guilty of, so let's hold our collective noses and acquit him. I think that's something that's been going on for a while, and it's been problematic, and I think the rule I'm looking for is that the judge should be instructing on the law as it exists unless there's something really extraordinary here. And why this is not an extraordinary case where, you know, it is a reasonable tactical decision to waive self-defense is that defense counsel asked for an instruction on voluntary intoxication. Now, Judge Gaziano seemed very surprised by that, and I think maybe tried to talk him out of it a little, but he said, no, I want that. So the last page and a half of instructions on murder are actually talking about the defendant's state of mind at the time he shot him, and if, you know, did his intoxication, which is kind of a weak intoxication argument, did his intoxication possibly mitigate first degree down to manslaughter or second degree?
I'm confused. What is the evidence that supports self-defense here? What particular, the fact that the earlier incident, the guy pointed his finger at him?
And he also said to a friend, "Where do you have your thing?" Which would,
So we're gonna say you have to give a self-defense instruction based on an earlier altercation in which the defendant then drove back to initiate the, that's,
no, that's not actually what I'm arguing.
I'm confused by where there's self-defense here. I understand that in the exercise of caution, the issue is raised, but I don't, what is the evidence that would support a self-defense instruction here?
Well, after the shooting, the defendant got a ride to his roommates from his roommate. He was with his girlfriend and with Mr. Varner, and he talked about the shooting.
And what did he say?
And he said, in essence, I pulled up, and he came toward me and reached for his thing, or something to that effect, and I, you know, shot him. I shot him once and then once more.
And so, and his friend testified to that effect.
Right, but both, I think both his girlfriend, I don't remember if both his girlfriend or at least Varner testified to that. I think at least one person testified to that, maybe two. And so that, I think, prompted Judge Gaziano to say, you know, there's a self-defense.
So he made the offer to defense counsel. I can give this instruction.
Yes.
On what basis could the judge give it over the defense objection to it? I just don't understand how, it sounds like you're putting the responsibility on the judge to instruct on matters that the defense not only isn't asking for, doesn't want. How can we say that's appropriate?
I think it's appropriate because the judge's obligation is to instruct properly on the law. And what I'm asking for is I'm asking for, I come up here and I argue these things, and this is not the first time I've made this argument, where the practice of gambling with a defendant's life by saying, I'm not going to take an instruction, I'm going to waive an instruction that is supported by the evidence. I think that is highly problematic. I think that is a practice that really should end in Massachusetts. You know, if the law says this is a self-defense case, then it should be instructed as a self-defense case.
So is it up to the judge to determine what instructions would be appropriate? Say it wasn't brought up by either side. It's up to the judge to say, well, I'm going to give an instruction on self-defense, whether you like it or not.
I think it is.
How does that work with a defendant's right to present his own defense or to, you know, we can't override every aspect of a defendant's choice here.
Well, I mean, I think the defendant can still say, hey, he wasn't there. It must have been somebody else in a silver car.
But if he doesn't want the instruction, doesn't he have a right not to have the instruction?
I don't think he should have the right to waive an instruction that is supported by the evidence. And, you know, I guess there's two answers. There's the big picture, which is, do we really want trials, murder trials being conducted where the jury is not properly instructed on the law. And then there's the small picture, this case, where he waived a self-defense instruction where it was very clear that he was the shooter. And then he asked for an instruction on voluntary intoxication that puts him right back at the scene. I mean, how do you reconcile the two? I don't think you do.
So, also, even if he doesn't want the instruction, if there's a basis for the instruction, even if he doesn't want it, the Commonwealth can request it, and it has to be
That's
given
right.
under Commonwealth versus Woodward.
That's right.
I guess the concern, Mr. Cohen, is that it's the defendant who's facing life without the possibility of parole. And he wants, and if he wants to take a chance on going home, we're in a manifestly unreasonable analysis here. Is it manifestly unreasonable to decide I don't want that self-defense instruction, particularly when he, the defendant, from the Commonwealth theory, he drives all the way over, when it's all over at the club, he drives all the way over to where he lives and starts going toward him. Isn't that the defendant might want to say, I want to go home. I don't want excessive force, self-defense, manslaughter with a 20-year maximum sentence.
Well, I think his best chance of an acquittal is, look, my lawyer's going to argue that I wasn't there. But realistically, I was there. So let's let the judge instruct on the theories of defense that might be available to me.
Well, that certainly makes all the sense in the world, but is it manifestly unreasonable to choose otherwise?
I think it is in the present circumstances, especially where you ask for voluntary intoxication, which is, really not supported by the evidence. There's a little bit of drinking. Mr. Varner was drunk, but no evidence that Mr. Waller was impaired, and he was able to get in his car and drive 2-point-something miles and pull a gun out and shoot him and come back and empty the shells. I mean, that wasn't going to fly, and that did exactly what counsel was trying to avoid by waiving the self-defense instruction.
So you want us, as part of our 33E analysis, to include a claim that counsel was ineffective for failing to ask for this instruction?
Yes, I raised that in the brief, and I do want that too.
Okay, thank you.
Thank you.
Ms. Middleton.
Good morning. May it please the court, Bridget Norton Middleton for the Commonwealth. The issue that the defendant raises on appeal is whether it was error for Judge Gaziano to admit the testimony of Varner, the reasons why he left Brockton after the shooting. As I lay out my brief, the defendant's objections, I don't believe that it was a preserved objection. The objection was to relevance. He did not lay out for Judge Gaziano the arguments that he now makes to this court, so I would argue that it's an unpreserved error. And the first objection was relevance, and this evidence is relevant. The defendant highlighted Varner as a third-party culprit. The defendant did it in his opening. He did it in his cross-examination of Webb, who is the victim's cousin who came to the club. Through the testimony of Webb, he highlighted that it was Varner who was threatening the victim in the club and Varner who was the instigator. He did it with the cross-examination of Varner. When he was cross-examining Varner, he highlighted Varner's intoxication, but also brought up another incident at another club in Brockton that Varner was involved in, where there was a beef in the club involving a girl. In his closing, defense counsel again raises Varner as a third-party culprit. I think the quote was, "Trouble follows Varner." And he tells the jury that Varner is drunk and Varner's a liar. And also points out the fact that Varner claimed that he left town because he didn't want to be around shootings and murders, but that Varner actually went to go see one of Allison's friends the next day after the shooting to try to meet this girl, so clearly Varner's reason for leaving town wasn't credible. So I think in these circumstances, and when you consider that under third-party culprit, the Commonwealth has to disprove beyond a reasonable doubt that, or disprove that Varner was the third-party culprit, and the fact that the jury is going to be instructed that they can infer consciousness of guilt from flight, under these circumstances, the reason why Varner left Brockton was relevant, and the judge properly admitted. So then The unpreserved error that we get to on appeal is whether this was improper opinion testimony. And the best way to look at that is just in the context of what's being argued at trial, the evidence that's coming in, and what the prosecutor is asking Varner. And in context, Varner's not expressing his opinion, he's answering a question. Why did you leave? It goes to his state of mind of why he left. Varner never mentions the defendant. It's not a direct that I think the defendant killed this person. I think there's some cases in my brief where I cite where a wife opined that someone had killed her husband. That's not what Varner says. Varner says, I don't want to be around shootings. They come back to it again. So it's the first time, the night of the shooting, why is Varner gathering up his stuff when they're back at Ithaca Street? Why is he collecting his stuff? That's the first, I don't want to be around shootings. Varner leaves, the next day is going to go to Lynn. The prosecutor asks again, why are you gathering your stuff? And that's when he says, I don't want to be around shootings, plural, and murders, plural. So I think the jury can look at that and understand that he is not giving his opinion, he's stating what's obvious to the jury. He's basing it on what the defendant has said.
So it's not really a lay opinion objection. I mean, I think the objection at trial was wrong and the objection on appeal is wrong. It's not a lay opinion because he's saying why he left.
Yes.
That's within his personal, he knows why he left. The problem is that there's an improper use of that testimony. It can be used to suggest that the defendant's the shooter, and that's Mr. Varner's opinion, and that creates an undue prejudice. That's an improper use of the evidence, and there has to be a weighing of probative value and undue prejudice. That's the appropriate objection in the evidentiary analysis.
So I point out just a couple of things, is that Varner's not an expert, so the idea that the jury is going to think that this is a murder rather than a justifiable homicide, they don't get that.
That seems like
I disagree with my brother's claim that the prosecutor used this improperly in her closing argument. I argue in my brief that it's a very lengthy, fact-driven closing. Methodically goes through all the evidence. I don't recall how many pages, but it's a fairly long closing. And as I argue in my brief, when she's talking about Varner, the defense makes the argument that Varner's drunk that night, and you can't believe that anything that Varner says. And during cross-examination, defense counsel really tries to pin down how much did Varner have to drink that night. And the prosecutor is pointing out that when Varner really started to drink, when he really started to drink a lot, was back at Ithaca Street, that he had a few drinks during the day, drank at the club, he's trying to meet girls, he's having a good time, but when he goes back to Ithaca Street is really when he gets intoxicated. So she's arguing about Varner's credibility. Should the jury believe the things that Varner said, or was he too drunk to even remember what happened?
No, so here's the concerning line. The guy he was with at the club had gone out and shot someone. That's why he started drinking. He told you that.
Yeah, so what she's talking about is, in the context of the night, Varner, he's there to meet girls. The defendant comes back and tells him, hey, I just shot someone. I left that dude leaking on the sidewalk. I hit him once, I hit him again. He comes back with a gun, empties the shells into the sink. Varner's lived with this defendant for 3 weeks. He doesn't really know the defendant. So you have that. You have the admissions that are made at the house in Belmont Street. Then during the car, and this is placing the prosecutor's argument in context, the evidence in the car where the defendant is making more admissions that, he's directing the path, he's admitting that he shot him, the girlfriend feels the gun next to him, although Varner doesn't know that. So then they get back to Ithaca Street, the defendant makes more admissions. So the prosecutor is explaining, isn't it more likely that that's when Varner really got drunk? And in the evidence of this case, isn't it understandable that that's why he got really drunk, because he was shocked by what had gone on that night? And I think if the court looks at her closing in context, I disagree with my brother that she is highlighting this evidence. The defendant raises a number of claims on 33. The first one is that this goes against the weight of the evidence. He points out that Allison receives immunity and that Varner is likely third-party culprit. I lay out in my brief that what my brother is ignoring is how these two witnesses corroborate each other quite a bit, and that Hilaire, the other immunized witness who was immunized in the middle of trial, he corroborates other parts of their story. Then you have, so they're all seeing the gun, the different statements, and then you have the timeline, which I think is set up very well by the phone records and and also the Hess video. So you start with the Hess video, that establishes a timeline, gives the defendant time to get there. It shows Varner on the Hess video, much as he described, kind of lighthearted, talking to a girl. Puts them back at the house on Belmont Street, and then defendant says, I'm leaving, you don't need to come on this ride. Leaves. The phone calls from Varner and Allison, repeated phone calls to the defendant, show their concern, that they understand something's going on here, but it establishes a timeline as well. The defendant doesn't answer. They're calling right up into the time, 2 o'clock. By 2 o'clock, the Brockton police are rolling up in that house, and the victim is, by all means, has passed away, and he's dead on the sidewalk. At 2:04, the defendant picks up his phone, says to Allison, I'm on my way back. That's before you get to him coming back into the house, emptying the gun, making admissions, and all the rest of it. So I would suggest on this record that the verdict is not against the weight of the evidence. And if there aren't any other questions from the court, I would rest my brief and ask that you affirm his conviction.
Okay, thank you.
Thank you.
And we'll do one more.